Good morning and welcome. My name is Russ Morrow, and it's my pleasure to act as host for this week's virtual summit brought to you by NAPW. I'd like to extend a special welcome to the NAPW members joining us today. For those of you who may not be familiar with us, NAPW is an online and face-to-face community made up of over 850,000 professional women who join together to cultivate valuable business connections, develop professionally, and promote themselves and their businesses. To learn more about NAPW and the benefits of membership, please make sure to visit our website at napw.com. This morning's webinar, Legal Tips for the Entrepreneurial Business, is part of our 3-day virtual summit for entrepreneurs, where over the course of 12 interactive sessions, we offer some amazing information and guidance from experts who will provide insights on how to plan, how to launch, how to run, and how to expand your own business. Topics covered have included how to get started, how to market your business, how to manage your finances and your taxes, through to the benefits of using virtual professionals. So before I introduce our guest speaker for this morning, a few housekeeping points. Everybody is on mute, so don't worry about being overheard if you sneeze or you cough. And questions, we will get many, I'm sure. Throughout this morning's session, you'll be able to submit written questions, and we hope there'll be time to answer those at the end of the presentation. Now, depending on the volume, we may not get to all of the questions, but if that happens, we'll do our best to answer them via blog post, by email, but we'll find a way to communicate answers to you. And the question that always comes up, will you be able to see the presentation again if you miss something? Well, yes, I'm pleased to tell you that recording of this morning's webinar and all the others over the course of the virtual summit this week will be available to view here again on the BrightTalk platform and will be emailed to you. So it's my pleasure to introduce our guest speaker. Randy Houston is a co-founder and of counsel to Fort Court and Houston PC, where his practice focuses on trademark and copyright counseling, clearance prosecution, policing, and litigation. Randy has also developed a significant music and entertainment law practice, negotiating deals involving major label recording artists, representing individual musicians, actors, artists and writers, and speaking and writing on entertainment-related topics. In this session this morning, Randy will cover some of the legal obligations and issues to which you must conform as a business owner, and will provide you with some top tips to ensure your business is legally protected. Randy, thank you so much for joining us, and over to you.
Thank you, Russ. Very glad to be here. Good morning, all. As Russ said, my name is Randy Houston, and not to reiterate too much of what he said, but I do want to give you a little more background on myself, so that you know who is speaking to you and sort of where I come from with the information I'm going to pass on today. I am a 20-plus year attorney, as Russ mentioned, specializing in trademark, copyright, entertainment, and business law. I am also, as he did not mention, because it's not something that in my legal capacity I flaunt too much, I'm also a musician, composer, playwright, and filmmaker. I am also myself a 4-time entrepreneur. I have been a founder or co-founder of 2 different small, what we call boutique law firms. I've also started my own media and entertainment company, promoting my work and the work of artists and other creatives with whom I work. And I've also co-founded a performing arts school and professional theater in the New York metro area where I reside now. So I'm not sure if my legal work has sort of fed my entrepreneurialism or my entrepreneurialism has sort of fed my legal work, but I take pride in representing a number of, almost primarily representing small businesses, individual business people, entrepreneurs, and the like. So that's where I'm coming from. That is sort of what provides the groundwork for both my legal practice and the presentation I'm going to give today. So I want to give you a quick overview of the topics that I'm going to cover this morning, and then we'll go into them in a bit more detail. So first off, I'm going to talk about different types of businesses an entrepreneur or group of entrepreneurs may choose for themselves in pursuing a new business. I'm going to move on from there to talk about market research. And what I mean by that, and we'll get into that in a lot more detail, is looking around. Whatever your business may be, chances are someone has done that or something very similar to that before. And so taking a look around at what others are doing or have done so that you can avoid pitfalls and perhaps capitalize on things that others may have missed. The third point big point that we're going to cover is protecting your business. Obviously, something that's very important. There are a number of ways to protect your business, as well as a number of aspects of your business that need to be protected. So we're going to touch on that. I think something that is a very big issue, probably for a lot of you, and certainly for most new businesses, is the online versus brick and mortar. Are you strictly an online business? Do you have a storefront? Are you doing both? And the issues that may come up with either or both of those. And finally, because I hope that my discussion will spur a lot of questions or bring out a lot of questions from you folks, we're going to open it up to question and answer. I have a very, very casual presenting style. Typically when I'm presenting live in person, I don't mind stopping midway for questions and answers. And I'm glad to do that if there are urgent, pressing questions. But as Russ mentioned, all of the questions, you will submit your questions in writing. All of those will be captured. And so we're very sure not to miss any of your questions. So if you can hold those questions for the designated question and answer period, we'll do that. And one way or another, we'll make sure to get answers to all those. So let's go ahead and just jump right into it. Again, starting with business types. I think the most obvious type of business, and probably for entrepreneurs, the most common general type of business that is going to be appropriate is what we would just call a for-profit business. That's a very broad category, so I'm going to break that down a little bit. But most businesses, and probably 98, if not 99% of entrepreneurial businesses are for-profit entities, as opposed to nonprofit, which we'll touch on in just a second. The first and perhaps most common type of for-profit business is what we call a sole proprietorship. And very often, whether you intend to start a business or not, you have started a business, but you started as a sole proprietor. And the reason I say that that's common and it happens very often is because there's not a lot required for a sole proprietor to be, for you to be in business as a sole proprietor. The sole proprietor category would very broadly cover independent contractors as well. So for those of you who do consulting or any sort of contracting as an individual, you are, I would say, on the more formal side of being a sole proprietor. But really all that's necessary for one to be in business as a sole proprietor is for one to transact business. In a sole proprietorship, obviously, it's just you. There are no formal requirements or filings that you have to make with any state or federal entity other than tax, which we'll talk about in a little bit. There are no annual compliance filings that must be made with state or federal. It is just a matter of being in business as yourself, and perhaps even under an assumed name, which we'll talk about a little bit more in a second when we talk about LLCs. But a sole proprietorship is probably the most common, and it's usually where a lot of businesses start. And so moving on from there, I think going up in terms of complexity, more or less, the next most common business type, and certainly even growing more common, particularly for new and smaller businesses, is the LLC, or the limited liability company. That is not a limited liability corporation, which I think some folks use interchangeably at times. LLC stands for limited liability company. A limited liability company is similar to the long-standing corporate form, which we'll talk about in more detail in a second, that most of us are familiar with. But it is much less stringent. It is much easier to do, and increasingly more common. An LLC is a state entity. All of these we're going to find are, to the extent that they require any actual formal formation, they are state entities. So an LLC requires a filing with the state. It can be the state. It is most often the state in which you reside or in which you'll do business, but it does not have to be. There has to be generally some connection between you and your business and the state in which you form your LLC, but that is usually a minimal hurdle to clear. Limited liability company is member-based, so we'll talk about corporations in a second, but whereas we're all familiar with the term shareholder, limited liability companies are composed of members. Limited liability companies can be composed of a single member, and very often are composed of a single member. And so there is no need to have a group of you. There is no need to form a board or a group of members. Limited liabilities companies can be formed with a single member. The filing requirements at the state level, it is generally a simple filing fee, usually a couple $100. There is a clearance process with the state where the state in which you're filing the LLC or forming the LLC makes sure that there is no other entity existing with that name in that state. So this is very different than trademark or intellectual property or assumed name. I guess it more or less is an assumed name. So let me distinguish assumed names for trademarks. We'll talk about trademarks in a lot more detail a little bit later. The assumed name very generally is any name other than your own name under which you do business. It may include comma LLC or comma INC or corporation at the end, but any name under which you or a group of you do business that is not your own name is, for legal purposes, an assumed name. When you are, for example, a sole proprietor taking a step back, doing business under a different name, you may have seen the term DBA, which stands for doing business as. That usually requires a local filing just so folks know who is behind that assumed name. When you do an LLC, similarly, you can operate your business under the LLC name with or without the LLC suffix. You don't have to separately file an assumed name because you're filing with the state. So entities that are trying to find out who is behind that LLC name can find out who you are through your state filing. So filing requirements are pretty simple. Annual compliance requirements, there typically is an annual filing that's required. It has to do with income. It has to do, more than anything, is really just a way of letting the state in which you form the LLC know that you're still doing business under that name and that they essentially need to still be looking out for you. I think the most important attribute of the LLC that is making it more and more attractive to smaller businesses and new businesses is what we call the corporate veil. That's something I'll talk about as well when we talk about corporations in just a second. But the corporate veil is a legal fiction, which basically means that the individual or individuals, the members behind that LLC, have essentially a veil over them which shields them as individuals, and people who have claims or parties who have claims against the entity, the LLC, must go after the LLC and not the individuals. So this is an attribute that is provided by LLCs corporations and partnerships as well, all of which we'll talk about in a second, that is not present with sole proprietorship. It's the most obvious reason for picking one of these formal business types, because you want to protect yourself. Obviously, there are all sorts of insurance and other liability requirements or that you want to put in place, because there has to be what we call capitalization behind the entity, so that it's not merely a front for the individual and a way for the individual to avoid any sort of liability. But that is where the limited liability aspect of LLC comes in. You are protecting yourself as an individual or group of individuals from liability that might come from conducting business as the LLC. Okay, let's move on then to corporations, which we are probably all very familiar with. Certainly was before the LLC. The LLCs started to become really, really common and popular in the late 90s, probably spurred by the dot-com boom, but have become, I think, even more prevalent than corporations, particularly with there being so many new small and startup businesses. Corporation is also a legal fiction or a legal entity. It is what we call a non-natural entity. So you're forming a legal entity that exists and sort of legally lives and breathes, even though it does not do so naturally. The concept of the corporate veil, which I just talked about in the context of the LLC, comes from this corporation, the corporation concept, insofar as those who are the actual owners of the business or of the entity are shielded from liability as individuals, and the most of the liability that may come from doing business is going to be directed at the corporate entity and not the individuals behind it. Corporations are shareholder-based, whereas we talked about LLCs are member-based. Corporations are shareholder-based. And so the individual owners of the corporate entity are referred to as shareholders. They do not have to be equal in stature. They do not have to make equal investments. In fact, they don't even have to necessarily make financial investments in order to be shareholders. Very often, senior employees are those who helped, for example, bring the technology to a business, are given a shareholder interest even though they haven't made a financial contribution. So shareholders, typically the liability of a shareholder in a corporation is limited, going back to this limited liability concept, is limited to your contribution. So if you were a shareholder, for example, who paid $10,000 for your interest in the company, your liability, to the extent that we go beyond any liability that applies to the corporate entity, your individual liability is going to be limited to that $10,000 that you bought in for. Similarly, if you are a brilliant inventor and it is your technology that forms the basis of this company, and let's say you were given a 40% interest in the company based on your technological contribution, your individual shareholder liability is going to be limited to that contribution you made, which was essentially an in-kind or non-monetary contribution. And so you are, at least in theory, going to be able to avoid any monetary liability. There are two general types of corporations, which I'm going to touch on a little bit more when we talk about tax in a second. But there are, and you may have heard these terms, S corps and C corps. Those are taxation concerns. And all that simply means is an S corp. If you are an S corp, it means that the taxes of the corporation are paid by the shareholders, and therefore at the tax rates of those shareholders, versus a C corp, which simply means that the corporation itself pays the taxes and is going to pay taxes on income at the corporate rate, which is going to apply to the corporate entity. So those are the two types of principal types of corporations for taxation purposes. In terms of compliance and annual filings for a corporation, those are somewhat more stringent than an LLC. If you are a public corporation, meaning you are selling shares or securities in the company publicly, much more stringent. The Securities and Exchange Commission, or the SEC, is involved. Generally speaking, for your average run-of-the-mill corporation, however, you're going to have required filings. You're going to have form a board, and certain things are going to be required of your board. It's a very good idea, though not a legal requirement, to have a general counsel or legal counsel, who is often the secretary of the corporation, to make sure that you're meeting all of these compliance requirements and making the necessary filings each year. So that's corporations in a nutshell. Let's move on then to partnerships, which again is very common and is often formed without the parties involved even realizing they have formed a partnership. There generally are two types of partnerships, and they're not formal types in the sense that you choose one or the other necessarily, but from a legal standpoint, there are two types of partnerships: what we call de facto, DE, second word FACTO, de facto partnerships, and there are de jure, DE, next word JURE, de jure partnerships. A de facto partnership is simply a partnership that, in the eyes of the law, will be recognized as a partnership whether or not the parties intend it to be. So very often when two or more people go into business together, the way that they conduct themselves, the way that they hold themselves out in that business without any formal filing or otherwise, may make them a partnership in the eyes of the law and subject them to liability and taxation and things like that as a partnership, whether they intend it or not. On the flip side, a de jure partnership is one that is actually formally comprised by the partners making it up, complete with a partnership agreement. Often there is some sort of partnership filing with the state or states in which they do business, so that is a more formal. So I guess the way to look at de facto versus de jure partnerships is an informal partnership versus a formal partnership. Partnerships obviously are partner-based, so the members of that partnership, those with the ownership interest in that partnership, are referred to as partners versus shareholders in a corporate environment or members in an LLC. And there are, for operating purposes and for liability purposes, there are, generally speaking, two types of partners that one can be within a partnership, and therefore two types of partnerships. There's what we call a general partner. A general partner is one whose liability is unlimited. And liability in a partnership is what we call joint and several, meaning that if a person has a claim against a partnership, they can go after one of the general partners, they can go after all of the general partners, they can go after some of the general partners. Joint and several simply means whatever liability attaches to that partnership entity is shared equally among all of the general partners. Related to that, then, there are what we call limited partners. And you may have heard the term limited partnership. A limited partner is one who, as you may have guessed from our discussion of limited liability companies, your partner liability is limited, and that may be limited however the partnership decides it's limited. It may be limited to your contribution, financial or otherwise, to that entity. It may be limited on some other basis. Every limited partnership has to have at least one general partner. So that, in other words, you can't have a limited partnership where all of the partners have their liability limited, because there is no, unlike with an LLC or a corporation, there is no entity above the partnership to bear that financial responsibility. It's shared generally equally among the partners. So in a limited partnership, you could have a limited partnership of 100 limited partners as long as there is one general partner. The other thing to keep in mind is that any or all of the partners in a partnership can themselves be another entity. So you can have a partnership that's made up of two partners, both of which are LLCs. And so then you get into sort of levels of liability. So if you have two general partners who are LLCs, then those two LLCs have joint and several liability for that partnership. But then the individuals who make up those LLCs, their individual liability is still limited by the corporate veil of the limited liability company. So that may be a little more in the weeds than I need to be, but I just want to explain how convoluted, let's say, partnerships can be. Moving on then, not-for-profit corporations. As I said, it's most unlikely that, I shouldn't say most unlikely, most folks who have the entrepreneurial spark tend to be looking at doing something in the for-profit space. There are, however, those among us who form nonprofit entities, be it for charitable or educational or arts-related reasons, and we are looking to form not-for-profit or nonprofit corporate entities. This is a very, very, I'll say, exclusive category of businesses. Only certain types of businesses engaged in certain types of activities qualify for nonprofit corporate formation. Those are typically what we think of as charitable organizations. So public interest, arts-related, educational, health-related, again, the types of businesses that we most commonly donate to, particularly at the end of the year. Giving Tuesday, for example, is something that's going to be upon us, I guess, a week from next Tuesday will be Giving Tuesday, the Tuesday after Thanksgiving, when a lot of nonprofit or not-for-profit organizations start making appeals. The types of organizations that we are thinking about that we often donate to are the types that are going to fall under this nonprofit category. Again, very stringent requirements. It often takes a year or more to form a not-for-profit entity. There is a board requirement. There are all sorts of filing requirements. And of course, the biggest advantage of being a not-for-profit is the tax-exempt status, which then will segue us in very nicely to the tax implications of each of these types of business entities. So just going down the list in the order we started, a sole proprietor is solely liable for the taxes of that sole proprietorship. There is no, typically there is no business entity. All the tax liability, income tax liability, and other tax liability falls on that sole proprietor. There is no pass-through. Your tax ID number for purposes of operating as a business is your Social Security number. And so that's an obvious reason why that sole proprietorship has become a less attractive business choice for folks. LLC, again, the individual members will have individual tax liability based on any income that they draw from that business, but the greater tax burden for that entity is going to fall on the LLC and will be taxed at the appropriate corporate rate. Corporations, again, we talked about S Corps versus C Corps. So that just determines who in that corporation is going to pay the income taxes of that corporate entity and at what rate they're going to be taxed. So again, an S Corp, shareholders are paying the taxes. They're going to pay the taxes at their individual shareholder rates, whereas a corporation or C Corp, corporation is going to pay the taxes at a higher, typically higher corporate rate. Partnerships. Partnerships are a business form that is again falling out of favor. It used to be very common in my world among law firms. Typically were partnerships, but more and more even law firms are moving to some of these other limited liability forms and various hybrids that are available in different states of these limited liability forms. But partners are taxed individually. There is, as I said before, there is no overlying entity as there is with a corporation or an LLC. So all of the tax liability is passed through to the partners, and it's generally proportioned based on your interest in that partnership or your contribution there too. One thing that's common with partnerships and had become an issue with partnerships is, for example, in the law firm space, when a law firm operates in more than one state and therefore earns income in more than one state, the partners in that entity would have to file tax returns in all of the states in which they do business and earn income. That is something that can be avoided by choosing some of these other types or variations on these other types. But the tax implications for a partnership can be extremely burdensome, and that's why that business type has definitely lost a lot of favor over the last, we'll say, 15 or 20 years. Moving on, let's talk about market research. As I said at the outset, typically, I know that there are a lot of new businesses out there, a lot of entrepreneurs and businesses launching into areas or providing goods or services that have never been provided before. But there is almost, in the business space, almost everything has been done at one time or another. Even if the product being sold has never been sold before, the way that product is being marketed and or sold probably has been done before. So it's really, really important to do your homework before you launch into a business and know what else is happening in your space and in the general space. So the first point I want to cover is, who is your competition? As I said, even if you are providing a product or service that has never been provided before, it is highly likely that you are still competing with people who are providing a similar service or an analogous service that because your service, good or service, or product or service is brand new, people don't know about it. So maybe there's something else that they were doing to get that before you came along. That's your competition. Until you can convince people that your product or service is a better way of doing X, they're going to continue to do it the old way. And whatever and whomever that old way is, that's your competition. So it's very important to look around, find out what people are doing. If your product or service is not brand new, it's important to look around and see who else is doing it, whether they're in your local geographic area or whether they're halfway across the world. Because of globalism, because of the internet, no one is really locked into their own local area anymore, particularly with various new types of businesses and entrepreneurial ventures that we're seeing. So I'm going to talk about that in a lot more detail in a second. But again, very important to look around, find out who your competition is, whether they're direct competitors or just an alternative. What are your competitors doing? What I mean by that is if in fact they are selling exactly the same product or service that you are, how are they doing it? How, in terms of by what means are they doing it, but also how are they doing? Are they successful in marketing this product or service a particular way? Is there something that has worked for them that you can learn from? Is there something that has been a dreadful experience for them that you want to avoid? The means by which you are going to do that research are going to vary. There are some competitors, depending on the nature of your business, that are going to be, their marketing and advertising, for example, is going to be very, very public. And so you'll be able to go out there and see what they've done. You may have colleagues or counterparts in a competing business who will be willing to give you a little bit of intelligence about what they've done and what has or hasn't worked for them. But it's important to not have to reinvent the wheel if you can avoid it. Again, if you are providing a brand spanking new product or service that no one has ever provided before, there may not be a lot of background for you to learn from. But to the extent that there is, you want to take advantage of that, and you want to, as I said, not reinvent the wheel. Learn what you can before you jump out there. finally, can you compete with them fairly, and can they compete with you fairly? And fair versus unfair competition is sort of a legal entity that I won't go into too much detail about. But what I generally mean by fair or unfair competition is, are there, if you are, again, let's say for the sake of argument, you're providing a product or service that others have provided before. Can you compare yourself to them and say, we're better? We're a better alternative. Here's why. Can you do that fairly? Because again, if there's already an existing market that you are now tapping into, folks that need the product or service that you're providing have been getting it from somewhere else before. Those are your competitors. Can you now enter the market, compete with them in such a way that you're going to attract attention to yourself and away from them, but do it in a legal manner? So that's something that you don't necessarily need to consult a lawyer for, but it can get tricky. And comparative advertising, probably the most recent example of comparative advertising that most of you may be aware of that has run into legal trouble is Papa John's Pizza. The tagline, "Better Ingredients, Better Pizza," ran Papa John into some legal trouble, and that is a case that has not only gone to trial court, but that has gone up through the appeals courts in a trademark sense, because better is a qualitative statement. It's comparative advertising. He's necessarily comparing himself to his competitors by saying better ingredients, better pizza. Well, better than what? Better than who? And so that's probably an example that doesn't apply to any of you, but just a well-known example of comparative advertising where there were legal concerns and a legal case was made. So let's move on then to talk about how you want to protect your business. Regardless of the business type that you choose, and I'll take a step back and say the business types are fluid. You may begin your business as a sole proprietor, and then once things pick up, you may decide to become an LLC or choose one of the other corporate forms. So the business types are not static. They can be very, very fluid, but generally speaking, depending on the market that you're going into, regardless of the business type you choose, the market that you're going into, or the type of business that type of market that you're entering into, there may be certain licensing and or permitting requirements that you have to comply with. For example, if you are running a storefront business, on a very basic local level, you are moving into a physical space. You need to make sure that that space is zoned and accordingly permitted for the type of business you're conducting. If there have been, let's say, clothing businesses in that space before, and you are opening an eating establishment, a coffee shop, a cafe, a restaurant, there may be very different permitting requirements for that type of business. And in fact, it's possible that restaurants aren't even permitted in that space because the area or the physical building that your space is in is not zoned for that. So licensing, permitting are things that you're going to want to look at well in advance before you open your business. You want to make sure if you're opening not just a physical business but also an online business, that you are dotting your I's and crossing your T's in terms of licensing and or permits for the type of business you're conducting, the way you're conducting it, and where you're conducting it. Marketing and advertising, I think, probably goes without saying, is a critically important part of any business. Without that, you are the proverbial tree falling in the forest. If people don't know that you are out there, if people don't know that you exist and what you have to offer, they're not going to come to you. So a probably most obvious way of protecting, and I'll use the word protecting in quotes here, a most obvious way of protecting your business is to effectively promote it. Because if you aren't effectively promoting yourself, you're not going to find customers, people aren't going to find you, and your business isn't going to last very long. the final point here under protecting your business is sort of my wheelhouse, intellectual property. Uh, Almost without exception, no matter what type of business you are starting or what type of business you're conducting, you have some intellectual property that you need and want and need to protect in order to keep your business thriving. It may simply be your name, the name of your business, or the logo with which you promote your business. It may be as simple as that. On the flip side, or the other end of the spectrum, some businesses are all intellectual property. If you are a technology-based business, for example, your entire business is intellectual property. And so it's incredibly important that you identify all of the intellectual property, be it the subject of trademark, copyright, patent, or trade secret. I'll talk about each of those in just a second. Identify all the intellectual property that makes up your business and make sure that you are adequately protected. So let's talk about each of those types of intellectual property. Trademarks. Trademarks and copyrights, I have to say, in my almost 25 years of practicing law, the use of trademarks and copyrights interchangeably is one of my biggest pet peeves, but it's also the reason I exist. To advise clients on the difference between a trademark and a copyright. So a trademark protects goods and services, protects the protects the purveyor of goods and services as the source of those goods or services. Okay, a trademark does not protect in mass. It protects very specific goods or services. So, for example, you can have Apple computers. Apple is the brand name or the trademark of this computer company, but you can also have an apple that you buy at the grocery store. And there is no conflict there. Apple for the fruit is not a trademark because it's not identifying the source of that apple. Washington apples, for example, it's not a protectable trademark, but Washington apples might identify the source of those apples, but it doesn't identify source in the same way that Apple computers. When we look at an iPhone or we look at an Apple computer, we know that that comes from the Apple Computer Company of Washington State, ironically, and we can look to that as the source, and we then can come to rely on that trademark as a source of reliable goods and, to a lesser extent, services. So that's what a trademark, that's the function of a trademark, is to identify a source of goods or services. Copyright, by contrast, protects the original expression of an idea fixed in a tangible medium. So copyright typically protects creative works. Those may be books, they may be the text on your website, they may be plays or films or movies, songs. But that is the purview almost exclusively of creative. And by creative, I don't mean necessarily artistic, but original creations, or as I said, the formal definition is the original expression of an idea fixed in a tangible medium. So your logo, your business logo, if it is sufficiently creative, may be protected by both trademark and copyright, but they protect different aspects of that logo. So it's important not to use trademark and copyright interchangeably and to know which aspects of your business are going to be protected by one or the other. Patent protects original inventions that are novel, useful, and non-obvious. Those can be physical inventions. Those can be at the opposite end of the spectrum from physical inventions. We have what are called business methods. Around in the late 90s and the early 2000s, again because of the dot-com boom, we had a boom of what we called business methods patents, where people and entities created new ways of doing an old thing that was not necessarily tangible or physical, but was nevertheless novel, useful, and non-obvious, and was therefore susceptible to patent protection. A lot of those business method patents have been challenged and struck down since, but that is what patent protects: know-how, technology, and those types of things. Trade secrets are somewhat related to patents. However, whereas a patent requires that you make all of the aspects of your invention public, and you get a monopoly in capitalizing, or the term that we use is exploiting. That's a term for intellectual property. When you are using your intellectual property to the exclusion of all others, you are said to be exploiting your intellectual property. So when you obtain a patent, you disclose all of the aspects of the invention, but you have the exclusive right, a monopoly, for a limited period of time to exploit that invention or to license others to do it. By contrast, trade secrets protect the same types of things, but you're not required to disclose them or make any kind of filing. In fact, the object of a trade secret is, even though it protects the same types of technology and know-how, is to keep it completely secret and to not expose it or share it with too many people. And therefore, a trade secret, such as the Coca-Cola formula, is probably the most well-known trade secret. It is not the subject of patent because patents end, right? And once a patent ends, it's in the public domain. A trade secret, as long as it's kept sufficiently secret, can be maintained forever. And so that's the advantage of one versus the other. So when we talk about intellectual property concerns, those are the four principal types of intellectual property that we're talking about. Let's touch quickly on online versus brick and mortar concerns. I think the distinctions between the two are going to be very, very obvious. When you are an online and strictly an online business, there are a lot more concerns because you're essentially putting it all out there for the world to see, but unfortunately you're also putting it all out there for the world to take. And taking a look back, and let's start with intellectual property issues in online versus brick and mortar businesses. Intellectual property rights are what we call self-policing. What that means is, whereas if someone steals something, if someone steals your car, you go to the police and you file a report. And the police, law enforcement, public law enforcement, will help you try and resolve that matter. Self-policing, intellectual property rights are self-policing. That means you have to find out on your own if someone's infringing your liability. And once you find that out, you have to go after them on your own. There is no agency, law enforcement or otherwise, that is going to go out and interrogate and penalize infringers for you. You are responsible for doing that on your own. Naturally, then, with an online business where you're putting your business presence online for potentially the entire world to see, your market then, even to the extent that you try and limit it geographically, is the entire world. And from an intellectual property standpoint, any intellectual property, be it simple trademark or copyright matter or know-how that might be protected by a patent or trade secret, once it's out there, it's out there. And so the biggest concern with an online business is who is going to be exposed to your intellectual property and what might they do with it. Trademark and copyright interests typically are territorial, meaning your rights, to the extent that you have them, stop at either your state border, your national border. You do not, unless you take additional steps, have rights in a trademark, for example, beyond the borders of your country. You can apply for international or individual country trademark protection. If you know you're going to be doing a lot of business in a particular country, you want to be protected there, that's something that you can provide for. Similarly, there are copyright treaties that will extend U.S. protection of U.S. works beyond the borders of the United States. But that's a big concern. Whereas if you're just a brick and mortar business, your goods and services are contained in your storefront. And the only people that could potentially infringe, or that you have to be concerned about, are folks that might come into your storefront and look at or purchase your goods or services. This then relates to the geographic and market issues, which is the next point. Is your market your local town, or even your neighborhood if you're a storefront? Is your market the entire world? And even if you are selling a product that you only intend, or maybe that only works in the United States, is it possible that someone from, and I'll use China as an example just because they're notorious for intellectual property piracy, is it possible that someone in China is going to go online, purchase your product, reverse engineer it, and then sell it for less from China or even domestically? So those are the kinds of things you have to be concerned about. It's not likely that a Chinese intellectual property pirate is going to travel all the way to the United States, come into your store, purchase your item, take it back to China, reverse engineer it, and then sell it. That's probably too costly and just not likely to happen. Whereas if your product is available on the internet, that is something you have to be concerned about. So I'm raising these issues not because I want to stir up any sort of corporate terror among those of you listening to this, but I want to just identify issues and concerns that are out there that you need to think about. I think for the majority of you, some of these far-reaching geographic online versus brick-and-mortar concerns are not going to be issues at all, but I want to raise them so that we're all aware. So with that, we are winding down to the last 10 minutes or so here, and I want to go ahead and open it up for questions. I've covered a lot, so I understand we may not get through everything in this question period, but I will be glad to work with Russ to make sure that we get all of your questions answered either during the next 10 minutes or afterward. So Russ, you want to jump back in?
Yeah, thanks, Randy. That's been an amazing session. You've covered so much in a short period of time, and I'm not surprised that we have got lots and lots of questions from the audience. So thank you to everybody for sending those in. So if I may, let me have a little look through here. We've got some very interesting and good questions. Here's one that looks interesting. I think you touched on this, but does the type of entity that I set up affect the tax I will pay on income earned?
It absolutely does. And so, as I covered in the very quickly, however, in the tax implications section, it doesn't necessarily affect the amount of tax you're going to pay. It does, however, affect at what rate you're going to pay taxes. So your income is your income, right? So if you earn $100,000 in a year, whether you're an LLC, a corporation, or a partnership, you still earn that same $100,000. But how you're going to be taxed on that $100,000 of income and what deductions or other subtractions may be available to you are going to depend on the type of entity you are. So if you're an LLC, if you're an S Corp, if you're a C Corp, if you are a partnership, first of all, there are going to be different tax rates for any of those types. And the deductions available to you for any of those types of entity are going to be different as well. So the income is going to remain static. The tax on that income will differ based on the entity type and deductions that may be available.
Thanks for clarifying that, Randy. That's great. Great question here that's come in regarding protecting business names. So thank you for asking this one. We've got somebody who said, how do I protect my business name as a sole proprietor without creating an LLC? So can there be two business names in the same state? For example, a sole proprietor and a limited liability company?
Okay, so that's a really great question. So I talked about the concept of an assumed name. If you are a sole proprietor and you don't wish to do business under your name, you can create, frankly, any name that you want under which to do business, but you probably need to do a doing business as DBA or assumed name filing. DBA and assumed name I'm going to use interchangeably. Typically, the way that works is you make a filing not at the state level, but at the county level in which you are located, in which your business is located, in which you do business. You make an assumed name or DBA filing, which simply identifies this is the name under which I'm doing business. this is who I am. So in case there is someone who has a claim or otherwise needs to find out the entity or person behind that assumed name, they can do so by going to the county clerk's office. This is contrasted with an LLC, and I see that there's another question about an LLC versus an assumed name. You can, as an LLC, just as you can as an individual, you can file a DBA or an assumed name filing as an LLC just as easily as you can as an individual. The idea behind the assumed name or DBA filing is simply that you're doing business under a name that is different from your business name or your personal name, and people that are doing business with you need to be able to identify who's behind that assumed name. So yes, as a sole proprietor or an LLC, you can make an assumed name filing. You do that at the county level. The county will do a minimal search as the state would to make sure that there isn't someone in the county already doing business under that name. And if you are doing business in more than one county, you need to file DBAs or assumed names in all of the counties in which you're doing business. If you're an LLC, you're already at the state level, so the state's going to do that search when you file your LLC. Hope that was clear as mud, but the point that I want everyone to take away here is that a corporate entity, be it a sole proprietor or an LLC, can separately file for an assumed name and does not have to do business under its own name.
Thanks, Randy. And I think you did answer a few questions there that had come in regarding that particular topic. So here's one. This is somebody who's starting a business. They say they're starting a business with some good friends. Is it necessary to have a detailed founders agreement when they start? And if so, what sort of things should this include?
Okay, can you give me the beginning of that again, the beginning of the fact pattern again?
Yes, this is a person who's starting a business with some friends.
Friends, okay.
Would you advise it's necessary to have a detailed founders agreement when they start? Now, I imagine that means, do you have to have things in writing to say that this is my percentage, this is what I'm going to do, etc.?
Yes, so I would suggest that any time you are forming a business with other parties, be they friends, be they family, be they colleagues, be they classmates, be they complete strangers, that you have some written document that clearly delineates who's contributing what the expectations are, what you're going to do, and how you're going to dissolve the company in the event that either the business doesn't work or things go awry among the group of you, how you're going to clear that up. That can be done in the form of a formal partnership agreement. That can simply be a letter agreement. I think the thing that's most important here for people to keep in mind is, the lawyers may hate me for this, but you don't need a lawyer to do all these things. A legal document does not have to be, or I should say, to be a legal document, it does not have to be prepared by a lawyer. What you need is a document that everyone agrees on that spells out very clearly the parameters of that business relationship. So whether it ultimately becomes an LLC or a corporation or a partnership, having that document is going to help clear up so much in the end. And it may help you when you choose a formal business type in how you proceed. I mean, it may dictate, frankly, how you proceed as a formal business type. For example, if everyone is, if it says that, if your founding agreement, let's say, spells out your ownership interest and you have disparate ownership interests, there may be business types that are going to be more attractive than others because you don't want to treat certain people equally. So this type is going to be more attractive versus another type. But yes, my answer, no matter the business type you choose, and even before you worry about choosing a business type, spell it all out very clearly in writing, make sure that everyone is in agreement, and then have everyone sign it. That is an agreement. And whether it's drafted by an attorney or not, as long as everyone agrees on it and it's very, very clear, it is a legally binding document.
Thanks, Randy. Great advice. We are very rapidly coming to the end of the session. There's still lots of questions, and I know you very kindly said that you will assist us in getting these answered and getting them back to people. It's quite an interesting one here, and I'd love just to get as a final question to you. What are your thoughts about our members, our attendees today using online tools like LegalZoom to help them to get through the minefield of legalities?
My thoughts in a nutshell, they are very effective. LegalZoom in particular, I can tell you without disclosing too much that I've used LegalZoom to form my own LLC. And so I highly recommend LegalZoom in particular because it's the one I've used. But I think generally speaking, legal online tools can be very, very effective. LegalZoom just happens to be the one with which I'm most familiar, but I highly recommend it.
Fantastic, Randy. Thank you. And I know we could go on for some time. There are so many questions. Thank you, Randy, so much for sharing all this knowledge today. You've been a great help. Recordings
Thank
of
you for
this
having
session.
Me.
No, thank you, Randy. So recordings of Randy's session and all the others over the course of the virtual summit this week will be available to view here on the Bright Talk platform, and this will be emailed to everybody who's attended. If you haven't already done so, please make sure that you register for and attend the other sessions that are taking place today, as well as watching the earlier sessions that have taken place over the last 2 days on demand here on Bright Talk. And please also remember to visit napw.com for details of the benefits of membership. Randy, brings me to bring everything to a close. Thank you once again for your time and for sharing today. Thank you to everybody for joining us this afternoon. I look forward to welcoming you to future NAPW sessions. Thanks and goodbye.